Hello and welcome to this Russell-Cooke webinar. My name is Ed Cracknell. I'm a partner in the property litigation team here at Russell-Cooke. This is going to be a very quick canter through the restrictions affecting commercial landlords and tenants during the coronavirus emergency. But if you do have any questions that are not answered by this webinar, do feel free to get in touch, and my contact details are at the end of the presentation. So the first thing I am going to talk about is that the government has announced a code of practice. The code of practice for the commercial property sector is completely voluntary. Parties don't have to comply with it, but I will briefly mention a few of its details. It applies to all commercial leases held by businesses which have been negatively impacted by the COVID-19 crisis. It encourages discussion between the parties, so tenants seeking concessions should explain why they need one, and landlords should grant concessions according to the code of practice when they can afford to. And if landlords are not intending to grant a concession, they should give reasons for their refusal. The code of practice goes on to suggest a few options for concessions: rent reductions, deferments, paying rent monthly rather than quarterly, all of the sorts of things that landlords and tenants really are already talking about. The code of practice does also go on to discuss service charges, and given that service charges are not profit making, generally speaking, it recommends that they should be paid in full. But where landlords make a net saving, it recommends that that should be passed on to tenants and passed on as soon as possible. So not necessarily at the end of the service charge year, as it might ordinarily be. So moving on to the forfeiture ban, this prevents landlords from forfeiting commercial leases for rent or any other sums due under leases. It doesn't matter when those sums fell due. The landlord is not able to forfeit for any sums falling due under the lease. It doesn't, however, prevent landlords from forfeiting for non-financial breaches. As I said, it only applies to commercial premises, and it only applies to leases, so it doesn't apply to licenses or tenancies at will. The forfeiture ban has been in force now for some time. It originally ran until the 30th of June, but it has now been extended until the 30th of September, and it's possible that it might be extended again after that date, but that remains to be seen. Another one that's been restricted is commercial rent arrears recovery. This is the process by which a landlord can send a registered enforcement agent to the property to collect the rent or seize assets to be sold. It applies only to written leases of commercial premises, and the agent must give a 7-day notice before entering the property. Now, the state of the law now, having had a couple of changes during the coronavirus period, is such that if the enforcement agent's notice was served before the 25th of April, the original rent threshold of 7 days applies. So that means the enforcement agent can go in and seize assets if there is 7 days or more worth of rent outstanding at the time. So if you're a tenant and if you've received an enforcement notice from an enforcement agent before the 25th of April, you do need to pay your arrears in full in order to avoid further action, or at least bring them down beneath 7 days worth. If the landlord didn't get his notice in before the 25th of April, but serves one after the 25th of April, there must be 189 days worth of rent outstanding, and that seems to be designed to be more than 2 quarters worth. So if a tenant is in arrears of the March and June quarters, that isn't going to be enough. There needs to be additional rent outstanding. That 189-day rule applies through to the 30th of September, and again can be extended. Statutory demands. Landlords have been serving a lot of statutory demands on tenants to try and compel them to pay the rent. A statutory demand is a formal threat to wind up a company or to make an individual bankrupt unless a debt is paid within 21 days. But what the new legislation says, or the temporary legislation says, is that no winding up petition may be issued at court based upon a statutory demand served on a company between the 1st of March and the 30th of September. So although it was only brought into force relatively recently, towards the end of June, it is retrospective in effect back to the 1st of March. It doesn't, however, affect statutory demands served on individual tenants. So with all of these restrictions on landlords' remedies, it's worth remembering that the rent is still due, and the rent is probably accruing contractual interest under the lease as well. And there is nothing to stop a landlord from issuing a claim at court to recover the rent as a debt. If the landlord decides to do that, he can add interest to the claim, as I mentioned, and he can also add the court fee, which is now in most cases 5% of the value of the claim, so it can be a fairly hefty sum, and also a small amount for legal fees. So that option is completely unrestricted by coronavirus regulations, and is something that tenants should look out for if threatened by landlords. Once the landlord has obtained a court judgment, he then needs to take further enforcement action, and that comes in a variety of forms, which is largely outside the scope of this short webinar. But it might involve sending a court bailiff to the property to seize goods. It might involve placing a charging order on land owned by the tenant, or it might involve a third-party debt order requiring the tenant's bank to forward directly any money owed to the landlord. So not really something that should be taken lightly. So in summary then, forfeiture, commercial rent arrears recovery and statutory demands all restricted until the 30th of September. So those restrictions have been extended from the 30th of June for another 3 months. There is a code of practice encouraging parties to enter into dialogue, and whilst that isn't binding, it is certainly sensible for both parties to discuss issues that they're facing and try to come to an arrangement to get through at least the next few months. If parties do agree a concession to the rent or any other arrangements at all, they must be careful to record those properly in writing. So that's it. I said it was a very quick canter, and that's pretty much everything I want to say. So my contact details are on screen. Do feel free to get in contact if you have any feedback or any questions at all. My email and phone number are there. Many thanks for watching.